The Court of Appeal is the highest court in the province. It has 8 full-time judges. The court sits in Regina and sometimes in Saskatoon. Unlike the Provincial Court and the Court of Queen's Bench, the Court of Appeal does not conduct trials. Rather, it reviews the decisions of other courts and, if necessary, corrects any errors that might have been made. The judges sit at a large desk at the front of the courtroom. Typically, 3 judges hear each appeal, although in very important matters, 5 or even 7 judges might sit. The judges wear black robes with white shirts and tabs. They are referred to in the courtroom as "my lord" or "my lady." There is no witness box in the courtroom because witnesses are almost never heard in the Court of Appeal. The lawyers sit at a table at the front of the courtroom and speak from a lectern. Their clients and the general public sit in the benches at the back of the courtroom. There is no general or open-ended right of appeal to the Court of Appeal. A party who is not satisfied with a ruling in a trial court may take his or her case to the Court of Appeal only if allowed to do so by the Court of Appeal Act, the Criminal Code, or some other statute. There are strict time limits for starting appeals. The most usual deadline is 30 days from the date of the decision in question. But this is not the situation for all types of appeal procedures. An appeal is started by filing a document called a Notice of Appeal. It must be formally given to or served on the party or parties on the other side of the appeal. The Notice of Appeal includes a written statement setting out the nature of the mistake the person who started the appeal believes has been made by the trial court. A special collection of the documents that are important to the appeal must also be filed. The parties on the other side of the appeal also prepare written arguments. The court has rules that explain how all of this must be done. After the written materials have been filed, the court sets a date for argument. On that date, both sides have an opportunity to appear before the court in person and explain their positions. The court might give its decision on the day of the argument, or it might reserve its decision for a later date. Court of Appeal decisions are not always unanimous. Sometimes 2 judges have one view, and the 3rd judge has another. If this should happen, the majority view prevails. Taking a case to the Court of Appeal can be difficult and confusing for individuals not represented by a lawyer. As a result, if you are dissatisfied with a trial court decision, it is in your best interest to consult a lawyer. Check out the Courts of Saskatchewan website for more information on what to expect when you go to the Court of Appeal.